Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to dive into the pistol brace rule again, but today we're going to dive in it from an entirely different angle, which is, hey, can I do amnesty registration as a gun trust? That question has come up a lot, and I've been actually bouncing back and forth with a three-letter agency trying to get some straight answers, and I think I have some somewhat straight answers to help you all get educated about whether or not this is even possible. I also have a loyal viewer who actually already tried to do it, so we're going to share some of his experience as well. So today, let's get you educated. Let's get you all up to speed on amnesty registration through a gun trust and why it's nearly impossible. Okay, so the issue we're talking about today is if you decide to comply with ATF's new rule on firearms with attached stabilizing braces and go through the Form 1 amnesty registration, can you do it as a gun trust? And the short answer is probably not. Now, before we get too far into this, I want to thank one of our loyal viewers, Staff Sergeant Eric O., who is serving right now currently in the great state of Texas. Staff Sergeant O., tried to create a gun trust and then say that his firearm was in the gun trust and do an amnesty registration that way. And unfortunately, it did not work for Sergeant O. He was, however, kind enough to share with us the correspondence that he had with ATF, and I want to share that with you real quick. This is how the ATF responded to Sergeant O. A stabilizing brace equipped firearm that is currently possessed by an individual after the date that the final rule is published in the Federal Register can only be registered to that individual pursuant to the final rule 2021R-08F. Any individual possessing a stabilizing brace equipped firearm in his or her individual capacity who wants to register the firearm to a trust or other legal entity must first register the firearm as an individual with the 120-day tax forbearance period, then submit a tax-paid ATF Form 4 transferring the firearm from the individual to the trust or other legal entity. To lawfully register the firearm to a trust, the trust must have possessed the firearm prior to the date that the final rule is published in the Federal Registry. Accordingly, you must submit with the application documentation that establishes the trust possessed the firearm before the date that the final rule is published in the Federal Register. And then the ATF concludes with, accordingly, any trust that seeks to register a stabilizing brace equipped firearm pursuant to the final rule must include with the E-Form 1 application evidence that establishes the trust is the current possessor of the stabilizing brace-equipped firearm and possessed it before the date the final rule is published in the Federal Register. This evidence will generally include the signed, dated, and notarized terms of the trust or trust schedules that list or provide a description of the property held in that trust. Accordingly, for trust applicants, ATF will perform a thorough review of the trust documents provided with E-Form 1 application to ensure the firearm sought to be registered to the trust was properly possessed by the trust before the date that the final rule is published in the Federal Register. Therefore, an E-Form 1 application to register a stabilizing brace-equipped firearm to a trust will be disapproved if the application fails to demonstrate the trust possessed the firearm before the date the final rule was published in the Federal Register. Okay, and so Sergeant O contacted me because he says, hey, does this make any sense to you? And it actually did, and I want to try to have it make sense to all of you so you can understand, because as many times as I think the ATF screws with you, the lawful and responsible gun owner nationwide, I'm not certain they're screwing with you in this particular instance. Let me explain why. For us average Joes who are not FFLs, okay, there is basically one of three documents, federal documents, forms that we will use to take ownership and come into possession of any firearm. Now, the one that we most frequently use, the 99% of the time we use, is the 4473. And that includes our handguns, our shotguns, our rifles, even our semi-automatic rifles, and all of our semi-automatic pistols with attached stabilizing braces, which means that when you accumulated those firearms, whether you accumulated it through a lower receiver and built it out from there, or you bought the firearm as is, the 4473 governed the ownership of that firearm, which means if we're going to look at this like a car, who has title to the firearm? Well, if we look at the 4473, the document that governs these types of firearms, and this includes all AR and AK pistols prior to the publication of this rule, the only information that could ever be associated with that firearm would be found on a 4473, and the only information here in Section B is for an individual. This firearm cannot be registered to any other entity, corporation, or trust. Any firearm that is governed by a 4473 will always be owned by an individual. You can create a trust. You can write it on your Schedule A and say it's there, but is there an actual transfer of title to that firearm to the trust so that the trust is actually the owner of the firearm? No, there is not. It is not possible through the federal paperwork. But you see, when we take a look at the other two forms that we could use when we come into possession of firearms, a Form 1, which is when we are assembling an NFA item, and that is the form that we're using to do this amnesty registration. Now, when we take a look at the Form 1 and who is the firearm being registered to, we actually see here that there are multiple choices because the application can be made by a corporation, an individual, other legal entity, a trust, or a government entity. So a Form 1, if our firearm is being governed by a Form 1, yes, it can be registered into a trust. Now, when we take a look at a Form 4, this is when we're going to buy an NFA item off the shelf. So we're buying that suppressor as is. We're buying that short barrel rifle as is. We would have to go through an ATF Form 4. And in this section right here on the Form 4, you can see that you can still register this firearm to a corporation, other legal entity, individual, or trust. So the bottom line is that when the rule published on January 31st of this year, the only firearms that could actually be legally transferred or have already been legally transferred into a trust was any item that had been designated as an NFA item by either a Form 1 or a Form 4. Only NFA items can we actually transfer, legally speaking, ownership into the trust. However, on January 31st of this year, when the pistol brace rule published, all of those firearms with attached stabilizing braces were governed by a Form 4473. And even if you list it as being in the trust, ATF is going to say that ownership of that firearm was still with the individual because that's what all the paperwork shows. Now, understand that there could be some unique state laws in your particular jurisdiction that allows a bill of sale or other types of transfers to occur where non-Title II or non-NFA firearms can be actually transferred into that trust. But in most instances, when people are building gun trusts and they don't have a single NFA item, it certainly helps as a nice estate planning document, but it's nothing unique that could not be done in the will as well. Now, I have been critical of the usefulness of gun trusts, but if we take a look at the estimates that there could be as many as 40 million firearms, which overnight, just like that, have been designated as now federally regulated NFA items, the usefulness and the utility of gun trust is going to increase exponentially. And why there was probably a very small segment of the gun-owning population in the United States that could actually truly benefit from having a gun trust until the publication of this rule, that now has significantly changed. There are millions and millions of more Americans out there that can now benefit from a gun trust. But the bottom line is this, is if you are going to try to do an amnesty registration as a gun trust, unless you can absolutely positively prove through paperwork that that gun trust previously owned that non-NFA item, we do not believe it is going to be possible, and therefore you will do the amnesty registration as an individual. That will come tax-free. However, once that Form 1 is approved, if you want to then transfer the item into a gun trust, and we will be doing videos on that, you will be using a tax-paid $200 tax Form 4 to do so. So you will get the first registration tax-free, but transferring it into the trust, there will be a transfer tax paid on that. That is why trying to do Amnesty registration as a gun trust is virtually impossible. Again, I encourage all of you, though, to consult with local attorneys because every state has its own unique state laws, and this may be possible in your jurisdiction. In the meantime, if you guys have any questions about pistol brace amnesty, gun trust, or what's left of our Second Amendment rights, you guys know you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.